Well, hello, everybody, and good morning. So, I have the paperwork that has been filed by both Jared Leisek from Adventures with Purpose and the state's objection to his motion to dismiss all his charges. Now, he is asking for his charges to be dismissed on due process grounds and statute of limitation grounds. I'm not going to read all through the document. I am going to show it, and you can pause it because there's just so much in here that I can't speak, like the SA and the R word and stuff like that. So I will just scroll through it. You can pause it and read it. Let me just see here. I want to present this so you guys can see it. Okay, so here's the document, and like I said, I will scroll through it. You'll see this is the Santape County Attorney prosecution that is filing this. It goes into what Jared is claiming and their objection to it. Why? You're going to see how Jared answered to each of the paragraphs and so forth. Like I said, it's just full of certain words that I can't repeat on here. So what I'm going to do is I will blow up each page so you guys can see it. Oops. As you're reading through. And it just says, comes now the state of Utah by and through counsel and hereby submits the following objection to the defendant's motion to dismiss charges on due process and statute of limitation grounds. So I'll go through the introduction here. Most of the defendant's argument in his motion to dismiss rely on his allegation the incident could not have occurred in 1992 and must have occurred earlier. The state denies all such statements of fact and asserts, as it has in the charging document, that the incident occurred in 1992. The court cannot rely on the defendant's alleged facts to dismiss this case in a pretrial setting, as all evidence is taken in light most favorable to the state and inferences are made in favor of the state. At this point in the proceeding, the only sworn statement before the court is that the R occurred in 1992 as charged by the state. I'm going to try and blow this up, you guys, as big as I can so you guys will have an easier time reading it. I will read through this part here, and then the rest I will just scroll through slowly so you guys can read it at your leisure. The defendant first argues there is a due process violation as a result of the retroactivity and post facto application of the law. This argument fails because the defendant could have clearly been charged with R of a child in 1992 at the age of 16 or 17. Second, the defendant argues the statute of limitation has run. In 1992, for a charge of R of a child, the statute of limitations would run 4 years after the matter is reported to a law enforcement agency. So the 4-year statute of limitation only starts once it's reported to law enforcement. This matter was first reported to law enforcement in 2022 and is clearly not run. Next, the defendant argues that because 30 years have passed, some unknown documents may have been destroyed, and therefore this case is fundamentally unfair to the defendant. The defendant can cite to no case law that is applicable to this case and fails to acknowledge that the passage of time is far more detrimental to the state than to the defendant. The state, having the burden of proof, is at a far greater disadvantage to proving its case because of the lack of physical evidence and loss of details regarding the crime. Lastly, the defendant argues that it's unconstitutionally unfair that if the defendant was convicted of R of a child, he would face a significantly larger sentencing outcome than if he had been convicted as a minor. This argument also fails. Utah law clearly anticipates cases where an adult is convicted in district court for a crime he committed as a minor, and the legislature has laid out several limitations on the court regarding sentencing, all of which ensure the defendant will not receive an unconstitutionally unfair sentence. So the next part of this is in the statement of facts that we did go over. He's saying statement 1 is denied. This is not a statement of fact, but legal argument. Statement 2, the state cannot confirm the statement at this time, therefore denies the same. Statement 3, the state cannot confirm the statement at this time and therefore denies the same. It's the state saying this. So statement 4 is admitted. Statement 5, the state cannot confirm the statement at this time, therefore denies the same. They're going to go over this, you guys. Again, this is just going over statement 6, the same thing. Statement 7 is admitted. Hang on. So sorry, you guys, I had a huge sneeze come on. So anywhere it's not admitted, the state cannot confirm this statement. So statement 7 is admitted, statement 9 is admitted. Statement 17 is denied in part. Amended information only argues that the defendant R'd the victim in Ephraim. I don't know how to pronounce that, you guys. It's okay, though. In 1992. Statement 18 is denied. While the victim made this statement at one time, she later clarified her memory, as it is memorialized in her sworn written statement, in which she states, Jared ended up in our home in Ephraim for the day, and while we were alone in the home, he progressed to, I'm not going to say the word, I don't know if I'll get demonetized for that, but as he had done before. They cannot confirm statement 19 or 20. So this is what the state is referring to up here when they deny it or they cannot confirm it. We'll see how far we can go here, you guys. State statement of facts. The state has filed an amended information alleging the defendant committed one count of R of a child in 1992. Number 2, in 1992, the victim was 9 years old. Her birthday is in January. Number 3, in 1992, the defendant was 16 or 17 years old. His birthday is on September 16th. Number 4, the R victim signed a sworn statement under a penalty of perjury stating that in 1992, the defendant was at our home in Ephraim for the day, and while we were alone in the home, he progressed to R me, or this word here, as he had done before. He used fear and bribes to convince me to let him. Okay, I'm not going to read that. If you guys want to read it, you can go ahead. I'm not getting into those gory details. That's pretty gross. Number 5. Pursuant to Idaho law, a 9-year-old cannot consent to intercourse. The victim never states the defendant lived in Utah at the time of the R, only that he was visiting her home for a day. Okay, so I'm just going to scroll through this, you guys, because like I said, there's a lot here that I cannot read. So you guys can read it. Pause this. You can read it. And it's very troubling, you guys. I just can't. I feel like I'm going to puke in my mouth already. If these are all found to be guilty as charged, he's, you know, anyway, I'm just going to mute myself because I know I cannot keep my mouth shut while I'm scrolling through this. It's disgusting. And if this is true, then he deserves everything that he's going to get. So I'm going to mute myself, you guys. So there you have it, you guys. That is the state's objection to what Jared has filed. Jared is looking to have all the charges against him dismissed. As you can see there, it goes into great detail about why the charges can be laid as they've been laid, even 30 years later, the statute of limitations on everything, what each charge bears as far as sentencing. Um, Even though 30 years later he is being charged only with this now, he would be charged, I'm sorry, he would be sentenced as the adult he is now, as if he was being charged back then when he was 17. So he would be sentenced as a young offender, which could possibly bring, I think it said 4 or 5 years in prison. And he would go to prison because he is an adult. So that's what they're stating there. This will be fought about. I'm sure this is going to go back and forth for a while. As far as I know, he is out of custody. A lot of people were asking me about, is he in custody? We've seen that he was booked into the jail. He was booked into the jail as per the order of the court to submit his fingerprints, get photographed, and then he was released on, I'm not sure if there was a bond, you guys, or if he was released on his own recognizance. But he has been appearing by WebEx, so he's not even having to, at this point, come to Utah from Oregon. So we'll follow this case, you guys, to see what happens, where it goes, what the judge decides, anything like that. I will let you know. I will probably just post that in the community tab. If you guys are looking for all my videos, please look under both the video tab at the top of my page. Those are for older videos from 6 months ago or longer. If you want any of the new videos, any of the lives, anything like that, they are all under the live tab. So any of the newer videos from 6 months ago and on are going to be under the video, under the live tab. So make sure you click on both. If you want to see the older videos, click on videos. If you want to see the newer videos, click on the live tab. If you have not subscribed, please hit that subscribe button. Hit the notification bell so you're made aware when we go up live and do updated reads and bring you update information like this. So until the next time, you guys, please take care of yourself. Please stay safe. Bye-bye for now.